Hi all, and welcome to our webinar. We're going to give folks a minute to join. I know we had a lot of people register and a lot of questions, so we're excited to dig in quickly, but we'll start in about 1 minute. Okay, it looks like people are still populating in on the attendee side, so we're going to give it another couple seconds and then we'll kick off. But thanks again for joining. Okay, well, I know we have a lot to cover, so we're going to jump into it pretty quickly. But for those who don't know me, I'm Noah Sudo, Senior Vice President at Whiteboard Advisors. We are so excited to be here with Charlie, Dennis, and Allison. It's been a wild 2.5 weeks, I guess really 2 weeks and a day since the new Dear Colleague letter was issued. We've gotten a lot of questions since then, and we're excited to put this webinar together. Really, in just a matter of days, we've had just a lot of people register for this, and we also received over 50 separate questions, 50, in advance for the webinar. So we're going to do our best to really go through all of them. We've taken some liberties in grouping questions together, but really hope that we can provide more information and more context about this new Dear Colleague letter and responsibilities for third-party servicers and institutions and what it all means. We're gonna do this in really 4 sections. We're gonna start with some terminology overview because there is a lot of acronyms and terms being discussed. We'll talk a little bit about the context for this, why is the department doing this, and then we'll spend most of our time really walking through the Dear Colleague letter and the variety of questions that we got about what it is, who's now a third-party servicer, who is not, and what it means. And then we'll spend a few minutes at the end talking about what's next. So, but before we get started, I really want to thank HMBR for collaborating with us on this. We're so excited to have you. We'll do a short round of introductions. For those that don't know Whiteboard Advisors, we are a strategy and research consulting firm to education investors, institutions, and executives. We advise on nearly every major educational transaction. We're former policy wonks. So just to give my background, I'm a former assistant vice chancellor for the Ohio Department of Higher Education and worked for many years on the state side. I'll toss it over to my colleague, Allison, to give her background as well, and then she can send it over to the HMBR team.
Thanks, Noah. So great to be with everyone. I'm Allison Griffin, also a Senior Vice President at Whiteboard Advisors. I have spent over 20 years in public policy in the higher ed space, starting my career actually as a policy advisor to the U.S. House of Representatives, Committee on Education and the Workforce, and now also chair the board of a public institution in Colorado. So bring a trustee lens to these conversations as well. Dennis, I'm going to toss it to you. Thank you so much for being here.
Oh, sure. It's our pleasure. And thanks. And yeah, just quick, HMBR at Hogan, Marin, Babbo and Rose. We're an education and healthcare law firm. It's focused on transactions and regulatory matters in the space. Myself, I was Deputy General Counsel for post-secondary education in the U.S. Department of Education under Secretary Spellings and then Secretary Duncan, which is where I met Charlie Rose, actually. And then I left and went out-house counsel for a while, and then ultimately paired back up with Charlie, and now we co-chair the education practice at Hogan Marin. Charlie?
Thanks, Dennis, and thanks, Noah and Allison. Good afternoon. My name is Charlie Rose, and as Dennis mentioned, I'm a partner at Hogan Marin, Babbo and Rose. I've spent my career representing education institutions in a variety of matters. Most relevant to this topic is my representation of higher ed institutions, as well as education-related businesses and regulatory compliance and transactions. And as Dennis mentioned, I also served as general counsel at the U.S. Department of Education during the first 2.5 years or so of the Obama administration under Secretary Duncan. So thanks again for having us, and we look forward to the discussion.
Awesome. Before we dig in, I do want to note that we do have a Q&A feature enabled. So if people do have questions, again, we got so many in advance that we have a lot to cover today, but please feel free to elevate things through that function. I'll start out with just some basic terminology. Allison, since you worked on the Hill, maybe you could help us start with what's the difference between a law, rule, and DCL, Dear Colleague Letter?
Oh, well, of course, we all know that the law or the statute is what we tend to go to, what we tend to gravitate toward when we are looking for understanding the boundaries of what we can and cannot do. Oftentimes that rule or the regulations are then further guidance that help policymakers and those who are implementing what is actually being surfaced. The issue at hand actually helps to guide the implementation. And then a Dear Colleague Letter is also sometimes known as sub-regulatory guidance that offers even deeper perspective and guidance around implementation of the regulatory framework or the statute.
Dennis, Charlie, I'm curious if you have more to add. And I'm also curious, like you both served, in the Department of Education. How do DCLs happen? What's the process?
There's an internal clearance process for issuing a Dear Colleague Letter, as Allison properly noted. It's called sub-regulatory guidance. Generally speaking, a Dear Colleague Letter is issued in connection with a particular policy objective that the department wants to accomplish. So there is an internal clearance process, as I mentioned, involving the key offices that are relevant to that particular guidance. Depending on the nature of the guidance, other agencies may become involved in the clearance process, such as the White House, Office of Management and Budget, Department of Justice, or perhaps other agencies with subject matter expertise. There's always a question about whether Dear Colleague Letters are binding. Importantly, a Dear Colleague Letter represents the interpretation of the particular statute or regulation that is the subject of that Dear Colleague Letter. While it's sub-regulatory guidance, it does represent, as I said, that department's or that administration's interpretation. Theoretically, I suppose an entity could challenge that by engaging in conduct that wasn't consistent with the guidance of the Dear Colleague Letter, and then if the agency took action against that particular institution, challenge it through the administrative process or ultimately in court to ascertain whether that particular interpretation embodied in the letter is accurate. But certainly, Dear Colleague Letters are important. They signal how the administration is going to move forward on an important legal or policy or regulatory issue. And generally speaking, the entities are encouraged to act in accordance with the interpretation that's outlined in the Dear Colleague Letter. Dennis, do you have anything to add to that?
Yeah, the binding question is an interesting one because it's more like the DCL is binding on the agency, right? It's kind of, if you comply with the DCL, it's a safe harbor. You are in compliance. There are times though where the DCL might be potentially at variance with the regulation, and so if you complied with the regulation, you would have an argument in court. I think the problem is in our system of justice, courts grant agencies a fairly extensive deference, and so if you get into that particular situation, you may have a bit of an uphill battle. Particularly going back to what Alice said about the statute here is pretty broad. That the regulation is a bit narrower might influence the judge's decision as to what the validity of the guidance.
Oh, You're on.
Allison, I was gonna say, if you want to lead us into the next section, this has been really helpful and insightful background.
Absolutely. So I'm going to set some context. Some of the questions around how did we get here? What is the problem actually that the department is seeking to solve? Dennis, I'm going to go to you first, and then we'll come back around with the group.
Sure. So I think there are, broadly speaking, two issues here. The department on the same day came out with the third-party servicer guidance, and then guidance related to incentive compensation for bundled service providers and the bundled service provider exception. For those who don't know, bundled service provider exception is, I guess, I don't even know if that's an exception, but it's treated as an exception to the incentive compensation ban, and it allows institutions to pay a revenue share to entities providing bundled services. So this would be recruitment, a learning management system, various academic support services, and so forth. This was related to guidance that was issued back in March of 2011 on the heels of the revised incentive compensation regulations. Well, these OPMs, as they're known, the bundled service providers, have come under some scrutiny lately, related to their the perceived lack of transparency and involvement in the schools, and the education that some would say that they provide. Obviously, the schools are very much in charge of the education in every one of these contracts, but critics have challenged that. And as a result, that is, I believe, the principal issue that's driving the entire topic. It's the OPMs. Relatedly, however, and the department talks about this in the front part of the Dear Colleague, the department does not have a particularly good understanding of all the service providers in the higher ed spectrum. And this came up back in 2015, which was the last time the department really issued a Dear Colleague letter on third-party servicer. There was a follow-on FAQ that was issued in 2016. But the department has this constant refrain that the higher ed sector is evolving and they just don't have a tab on it. They don't even know who to look at or who's involved.
Sure. Well, as a reminder, I mean, the last time the Higher Education Act was reauthorized was 2008. And so my reminder of that every day is my 15-year-old son. So, that higher education landscape has also evolved considerably in the last 15 years. And so it of course, on some sides, it makes sense that the department would want a little bit more information about the evolution of the broad ecosystem.
Right. It does make sense. And even just going back, we talked about the underlying statute. The underlying statute's even older than that, right? 20 U.S.C. 1088. And back in that time, third-party servicers were what we all traditionally thought of it as a third-party servicer. Financial aid processing folks like FAME or ECM or Global. You didn't have a financial aid office, they came in and did it for you. Now things have changed and the department is trying to get a handle on all of this.
Absolutely. So let's go to the DCL. What have been the concerns that the department both addresses in the DCL? And you mentioned the bundled services category, the safe harbor. When did that originate? Charlie, do you want to jump in here?
Sure. As Dennis mentioned, the Dear Colleague letter, which created the bundled services exception, was issued by the Obama administration in March of 2011. And the March 2011 Dear Colleague letter had a very specific purpose, and that was to allow what are now called online program management entities to work with institutions on a revenue sharing basis in order to, among other things, really build distance education or online platforms. 11, 12 years ago or so, 13 years ago, that aspect of delivering instruction certainly wasn't as robust as it is now and as pervasive as it is now. But the March 2011 Dear Colleague letter provided a mechanism to do that. As Dennis and you also mentioned, the growth, has prompted increasing scrutiny on the role of OPMs in higher education. So if you look at the TPS guidance that was issued a couple of weeks ago, particularly the first three paragraphs, the department references the Government Accounting Office report that was issued in April 2022 about OPMs. And in that context, the department seems to be saying in the TPS guidance that in order to address some of the concerns that were identified by the GAO, it's necessary to revise the TPS guidance and specifically revise it in a manner that identifies these core functions that third-party servicers provide, such as student recruitment, involvement in Title IV, and also instructional content and delivery, to encompass them. And what the TPS guidance does, and the regulation does more broadly, is provide a platform for transparency and ultimately accountability. And the structure of the particular guidance here picks up not only those OPMs that were traditionally thought of as third-party servicers, but because of the breadth of the guidance, picks up OPMs that typically were not thought of as third-party servicers. So it really uses the third-party servicer guidance to encompass the entire OPM industry and then subject the OPMs to the transparency and accountability provisions built into the TPS regulation.
Absolutely. And I thank you that that provides a really a good overview and a great level setting as we really dissect some of the elements of the DCL. And so Noah, as I turn it back to you, I would love your thoughts on why did this happen so quickly? Why so broad? Was this intended to be so broad? And then let's dive into some of the elements of the letter.
Yeah, and I'll even add in a little bit more on the context here, around OPMs, because I think Charlie's point is just really interesting around like it is really hard to define what this is. And there's been a lot of pressure, in particular on the revenue share side of this, especially from, certain Democratic members of Congress, think tanks, to really, they would say to stop the bundled services exception is sort of where the pressure's been. But really what they're asking for is a lot more information. And I think that kind of lends itself to why this is so broad, and thinking about how big that definition of like, what does an online program manager mean? Because it's beyond rev share, and there's people who fit into that rev share category that you probably wouldn't necessarily associate with sort of a traditional OPM. And there's just so much that is sort of unknown out there in the space. And I think that is probably, what the department, is one of the things that they're interested in, is really understanding the landscape, because in a lot of ways, as we get into the details about what does it mean to be a third-party servicer and complying and having to report your arrangement and things like that, it's so that the department is aware of this. I do also want to add really quickly that it's interesting that, and Dennis mentioned this earlier, that in conjunction with the Dear Colleague letter, they announced a listening tour around the incentive comp side of it. They could have just as easily issued a Dear Colleague letter that, amended the safe harbor, removed it, created more limitations on it, whatever they wanted to do there, but they didn't. And we've heard that there's, that people generally believe that there may be some good things, as Charlie was mentioning, that have come from, the safe harbor. It kind of like, your point about 2008, 2011 was a long time ago, especially if you think about the advances in online education, everything that happened during the pandemic. So there's a lot we need to learn, or the country needs to learn about online education and how these programs work, that I think, again, sort of to why it's so broad, maybe one of the reasons. But I'd be interested in, Charlie and Dennis's read too on, is the reason why this is so broad because it had to be so broad, or is there, or is there more to it?
Well, I don't know that it had to be this broad. I mean, I think the department could have come out with an OPM specific regulation. That because of that, while any of the underlying services may not be a third-party service to render a provider a third-party servicer, the combination of them could have made them a third-party servicer. I mean, I think there are a lot of things that the department could have done to be a bit more circumspect. I'd also note that in the fall, the department in its annual regulatory agenda notified the world that in April, they intended to publish a notice of intent to conduct a negotiated rulemaking on third-party servicer issues. So it's a little, I think I was surprised. I mean, I won't say it's surprised, maybe others are not, but I was kind of surprised. I figured that third-party servicer issues were going to dominate the regulatory agenda for a bit, but not quite yet. So I was surprised at the vehicle, and also surprised that if they were really trying to get at OPMs, that they weren't a bit more circumspect in how they did so.
Yeah, I tend to look at this guidance in two parts. One is OPMs and the other is non-OPMs. With respect to the OPMs, as I mentioned, the guidance through the transparency and the accountability mechanisms that are built into the TPS statute and the TPS regulation do go to some extent in addressing the GAO report. The OPM industry has really enabled many universities that simply don't have the capital to build online programs for the benefit of students and remain viable, remain competitive, and deliver a quality education. So that's one aspect of the guidance. By expanding the definition of a TPS, as the department did in the guidance, and this is what's generated so much concern, it has brought into the conversation many non-OPM third-party servicers that are vendors for higher education. And so that second category of entities that are swept into the TPS definition, and therefore the transparency and accountability mechanisms that are built into the TPS statute and regulation, is really what has been causing a tremendous amount of consternation. Given the breadth of the TPS guidance that was issued a couple weeks ago, my guess is that that breadth is intentional in order to ascertain just what are the nature of these relationships, even among non-OPM entities that do provide services to higher ed institutions. And then that's what's generated the questions, why the foreign service or why the foreign-owned ban? Why? What does it mean to be joint and severally liable? Those types of questions.
Yeah, and we'll get to those shortly, by the way. And maybe this is a good opportunity, given Charlie's comments, to sort of walk through like who's included, who's not included, or sort of the why behind that. And this was one of the most fascinating pieces of reviewing the questions in advance, was just see the number of types of tools or services that people were interested in. So I'll toss this one over to Dennis, but before we get there, I just want to list out, here are some of the entities that people were interested in learning if they're now a third-party servicer. Teletherapy, EdTech curriculum licensing providers, particularly in professional and continuing education. Computer, software, and services. People were interested in IT vendors, help desk, cybersecurity monitoring, other IT service providers, CRMs, OER providers, which is open education resources, LMSs. What about those that aren't tied to enrollment, but you're talking to students about their decision-making, about where to go to college or where to go to, for a job or career? And then we got a few different questions from state agencies. I know there's several that are listening to this webinar about whether or not they are now TPSs, especially if they perform FAFSA completion events or utilize FAFSA data to award state aid programs, which we know a lot of states do. So Dennis, maybe I'll sort of toss that really broad question, and so many different people are trying to figure out right now if they're a TPS. Are they? What should they do? What should they be thinking about as they read this DCL?
Sure. Well, I mean, to be honest, I mean, the answer to majority of those is maybe, right? I mean, you need to look at the contract and the operational relationship. When we've gone through program reviews, I mean, we've had this where a school has said, oh, this service provider is a third-party servicer, and the servicer may not necessarily agree with that interpretation. And so the department will come and do a program review, not just of the servicer, but of about 6 or 7 client organizations to see not only what does the contract say, but how does it operate in real life. So it's hard to say in any given case, just based on, you know, like, hey, I'm on, you know, an OER, does that make me a third-party servicer? I think that there are certainly some features here that suggest that some of these are more likely to be than others, like an LMS that provides monitoring of student activity. That sounds like that might be. I mean, again, I think though you really need to get to drill down onto what you do and see in what box it fills in. I mean, I do think in looking at this, we should be aware that the statute here is written in a broad way. I think that, again, just to get back to it, it talks about a third-party servicer is any individual, state, organization enters into a contract with a higher ed institution to administer through either manual or automated processing any aspect of such institutions' student assistance programs. That sounds fairly broad. Now, I think at the time, this is an older provision in the statute, that was probably focused on those financial aid processing servers that we talked about earlier. So perhaps that would be a real good place to have a revision is in the statute to really take into account what's gone on in the, I don't know, roughly 40 years since that statute's been enacted. I think in going through all of these provisions, you really need to sit down and say, okay, what is going on here, both in the contract and practically, and whether or not, you know, to assess with the school, I mean, and service provider to jointly assess, is this a third-party service or function? I think there are some things that are, I'd like to say, pretty clear. If you're doing work with non-Title IV eligible students, it seems like that's not, you're going to be okay. I'd like a little additional clarity on that, but I think that, you know, again, foreign students, they don't seem to be implicated into this. I think if you're dealing with non-Title IV programs, that again, I think there's a really good chance that that's not implicated. You know, the state associations, I mean, one of the exclusions here is if you're conducting, you know, FAFSA completion events that are general and broad, right? We're not talking about for a specific college, then that's probably going to be okay as well. But, you know, it's very difficult to say without getting deep in the weeds whether you're a third-party servicer. I mean, a good example, in the 2 weeks or so, I've had conversations, and Charlie and I have conversations with everybody from service providers to recruitment folks to the people that manage a what do you call it, like a marketplace for a kind of more unique lead gen type option, just traditional lead gen folks, and folks that do academic engagement counseling. And the answer to this is, yeah, kind of, just on a first blush, I could see why you're concerned, and maybe there's a way to deal with it. But, you know, even the telehealth option, I think that you mentioned, I mean, my guess is probably no, but, you know, is that related to maintaining academic engagement? Well, maybe, I don't know. So I think the department is going to, one helpful hint is, I think people should write letters to the department and comment. And even if you don't want to expose who you are for fear of kind of popping your head out and getting whacked. Having examples out there would be helpful, because I think, again, part of the problem here, again, it's a legitimate problem. The department doesn't know what it doesn't know. And so it needs to understand what the scope of the services are out there so it can make reasoned determinations. So I think that finding a way to comment would be helpful intelligence for the department.
Right. Just to follow up on Dennis's comments briefly, there's no doubt that the breadth of the guidance and by its nature, the general description of the activities that would lead to a third-party servicer designation, give rise to the concern, but also give rise to the potential application of it in a very broad way that sweeps in a lot of the entities that NOAA identified. Now, whether that was the intent or not, I don't know, but that's certainly the way in which the guidance was written. So in that regard, I think there's three things to keep in mind. One is that 2 days ago, the department, I think, did a very important act, and that was to delay the effective date to September 1 and extend the comment period. And by doing so, I think the department has signaled a willingness to try to address the concerns and questions that we've been hearing and try to generate some clarity moving forward in the application of the TPS. And like Dennis, I think it's absolutely critical that we share our comments and concerns and suggestions, frankly, for clarity with the department. The second is that I think we need to kind of look at this in sort of concentric circles. The initial paragraphs of the Dear Colleague letter identify three functions, that really generated the issuance of this guidance. And that is student recruiting and retention, provision of software products and services, and I think this is important, involving Title IV administration activities. And then finally, the third category, the provision of educational content and instruction. So, again, those are the three core functions. The breadth of the guidance perhaps picks up other non-OPM entities who are vendors that maybe extend beyond that, but I think that context is important. And then the third is, thing to keep in mind, what is the consequence? Well, the consequence is a compliance audit that needs to be submitted every year. And second, this notion of joint and several liability. And perhaps the department will provide clarity on both of those functions, but to the extent that entities that are picked up that weren't otherwise considered third-party servicers have some clarity on what joint and several liability means so they can build it into the business model. And second, what exactly is required with the compliance audit, perhaps that will also put this in perspective. So I think kind of taking a three-part analysis to this provides a context that we can use in moving forward and living under the guidance.
And I think the consequences piece, or sort of what does it mean to be a third-party servicer and what are the responsibilities of a third-party servicer is a great place to go. And one of the things that we've gotten a lot of questions on, including live, is around foreign ownership. Maybe we can spend a few minutes just talking that through, because I think a lot of people have been sort of surprised by that, trying to figure out what it means, who falls under that, especially with such a broad category. There could be implications, for investors, with who have sort of foreign entities involved. So maybe, Dennis and Charlie, I'd sort of be curious, like we got one in the chat that's asking, what's the basis for the for this requirement that they be U.S. based, and sort of what does it mean? And we're just curious to get your guys' take on why is this in there, and what the impact's going to be.
Yeah, I sympathize with the questioner there. I've looked. I don't see the direct statutory basis for this. The first time I've seen that this came up was in the 2016 FAQ document on third-party servicers, and the department very clearly said that third-party servicer cannot be a foreign-owned entity, and the department appears to have essentially just used that language and put it in here. I think that the issue here is, I mean, in the past it wasn't an issue because it didn't affect anybody. It affected very few people. Now you have, if it's affecting software providers or data hosting services that are literally on a global scale, now we have some real concerns. And I think what's also very unclear, the department will hopefully provide guidance on, as well as their statutory authority here for this, is what it means to be foreign owned, right? I mean, you look at that, it's not hard to come up with circumstances where if, a sovereign fund from another country owns, 10% of an enterprise, does that make it foreign owned? What if it's a global service company that has a US affiliate, that's the contracting entity, but again, it's a sub of a global entity? And then add to the fund, what if a New York private equity fund is the one who owns that global company? I think there are a lot of issues there. I think also unclear is what the department means when it says that the third-party servicer cannot be operated by an individual who is not a U.S. citizen or has authorization, a U.S. citizen or is legally present in the United States on a permanent basis. I mean, you think about the goals of the country and having people come from other countries and provide their expertise. That's why we have the whole the work visa system. I mean, it's a really important part of America and of higher ed generally. And why would we want to exclude those folks? I think there are just some legitimate questions. I hope the department clarifies that if you're here on a work visa, you can still be the CEO or CFO of one of those companies. But I think there are some real questions about that. The only thing I can think of is this goes back to data security issues. The department not long before this, dear colleague, came out with a note that third-party servicers had to be compliant with the safeguards rule, the FTC under Graham-Leach-Bliley, and the department has a long-standing history of being concerned about data security. You wonder if some of the issues that have come up, I guess, from TikTok and all these other foreign technology providers, that they're concerned about that in some way. Perhaps that's what's motivating it, but it seems like the 2016 FAQ is the source of this.
Right, and in the guidance, that the paragraph or the first paragraph on foreign owned issue begins with the lead in to protect the interests of institutions, taxpayers, and students. Again, that's a very broad statement. It could encompass national security interests, privacy interests, the integrity of Title IV interests, or all of the above. If the department is going to keep the prohibition or even narrow it, I think it would be helpful. And again, this is a subject for the comments and some suggestions on how to clarify it if it keeps it. To answer the question that Dennis raised, and what is the standard or what is the criteria by which the department is going to determine that the entity runs up against this foreign-owned prohibition and therefore is ineligible to serve as a third-party servicer? And then what kind of period will be offered to institutions and those entities to to work out a transition plan.
Yeah, actually, on the comment period, just to highlight for folks, and the department in the revised Dear Colleague specifically asked for comment on this point. They said, we are especially interested in comments on the impact of continuing the existing limitation on the institutions contracting with foreign entities. I think that that's helpful, that they are really trying to understand this. And again, this is part of that information gathering process. The department, just doesn't know who the services are or where they're from. And this indicates to me that they're not trying to be punitive with this, that they're just trying to understand. And while, as Charlie said, legitimately protect interest of taxpayers and students and institutions.
Go for it, Allison.
I was going to say, I mean, I agree on all of that. I think there's so many questions that we really need to, we need some clarity, of course. And I'll just speculate for a second on the challenge that this actually presents, to our institutions who have been relying on outside providers, whether foreign owned or US owned, with foreign ownership or employees, because we don't have the talent base necessarily here in the States to do some of the things that we've been relying on some of our global counterparts to deliver for our institutions. So we almost get in this catch-22 circle with some of the prohibitions or alleged sort of restrictions that are being placed on foreign-owned partners.
And
and I'll just say, just real quick, Dennis, I was gonna say, like, I want to echo your point before, because I think it's really fascinating that when the department extended the enforcement date, or clarified the enforcement date, and then extended the amount of time that people had to comment and submit the forms, the only other change they made was to note that they're interested in comments around foreign entities. And I think that sort of shows how much feedback they received and how much confusion they've created on this topic. And again, just a place that I think there hopefully will be more clarity that comes in the coming weeks, and something that people should definitely ask questions and sort of share, depending on how it is defined, what the implications of that could be.
And we're talking about the implications. I think it's also worth commenting about, again, if the department pursued this within, say, a limited sphere or whatever, if they're requiring universities to undo existing relationships in some of these areas, 6 months is not enough to undo them. I mean, you were talking about, some of these, there's, computer systems and various software systems to come off one platform and upload another to ensure that the operations are maintained can easily take over a year. And I think that's something as well that people that universities should be commenting on, that this is not only is it going to be incredibly costly, but it's going to take a long time. So we're going to need much more time to come off of some of these relationships.
Yeah, and just sorry, go for it, Allison.
I was going to say time and money. I mean, and I think of, some of our smaller institutions who, again, not being able perhaps to leverage the talent here or within their community, they have engaged in a partnership relationship to bring that system support in-house. And so not only undoing some of those relationships, but finding new ones, the time and cost and ultimate impact that will have on their ability to support students.
So let's just assume for now that some of the folks on this call may now be third-party servicers who weren't third-party servicers before, and we get more clarity and we're confident that they are, and then we get to September 1. What has to happen? What does it actually mean to be a third-party servicer? What do you have to do? What's the process look like? Maybe I'll toss that over to you, Dennis and Charlie, first.
Yes.
Yeah, go ahead, Ben.
Yeah, so I mean, just to set up, there are a couple of things that that make life different for you. The first is you are now a regulated entity, so the department can come knocking on your door and have program reviews of your enterprise, and if they send you letters, you've got to respond. And whereas now everything was through your client, if they had questions. Now it's a much more direct relationship. And I expect, given the information gathering piece here, and certainly with regard to OPMs, if you look at some of the questions on tuition sharing, I wouldn't be surprised. The department directly asked questions of you on how you pay people and so forth to ensure compliance with incentive comp at the very least. The second big thing is, which is not a particularly big thing, but your contracts are going to have to be revised. There is literally required language that have to be in the contracts to cover things like, what if you go out of business or go bankrupt, what data has to be ported over back to the school. And if you see something, you've got to say something. So if you see that the school is doing something that violates a Title IV regulation, you are supposed to report them to the Inspector General, which, again, there's a certain level of comfort for that, but I think most people that have had to deal with it, can do so intelligently. The two other big things that I think have caused the most consternation because of the lack of clarity are, first, with regard to the audit. You've got to do a compliance audit of your function. The problem here is the Inspector General's audit guide, which has been updated a couple times, but the main one has come back to 2016. It has not, it doesn't encompass a lot of these functions, right? So there's a lack of clarity as to what you're being audited for, which is coupled with the lack of clarity about what Title IV function am I doing. If I am speaking with students, I mean, this is on a recruitment, typically that's not a Title IV function as most would know it. I think there are some restrictions. You can't misrepresent things, certainly. So what does that mean? Do we have to do secret? Does my auditor have to do a secret shopper? Don't know. I think there are a lot of those types of questions that are very practical, may not be very costly, but that cause people some angst there. I think the other piece is this joint and several liability, which Charlie mentioned earlier. I think everybody knows what joint and several liability means. The problem is we don't know what we're joint and severally liable for. The department, in some emails with me in the past, has said, well, it's only related to what you do. But here, we'll take an example. You do software that helps a school calculate a return to Title IV, which is, for those who don't know, this is a process. School gets money, student doesn't complete their education, they've got to give some of that money back. That's a return to Title IV. So there's an error in the return to Title IV. Right now, the way it works is the department goes to the school and says, hey, you made an error, you've got to pay us this money. And then if the school says, oh, wait, that wasn't our fault, that was the service provider, there's probably some indemnity language in the contract that then they will deal with that. And that's been negotiated. Maybe there's not, and that's been negotiated as well. But nonetheless, the relationship is with the school. Now, if the service provider is jointly and severally liable, the department could very well say, well, look, both of you are responsible for returns to Title IV. You, the software provider, you, the school, pay us the money, right? You're both responsible. And it's doubtful the department's going to get into the nuance of like who was really responsible. Was it an algorithm problem, or was it, garbage in, garbage out, the data was bad? Or what was the issue? Maybe you just held the money too long. I think that's where it's very concerning, because very few people have priced that type of risk into the model. They've accounted for their indemnity obligations and taken insurance for it. But now this changes the nature of the risk, which will change the pricing. And I think that's where the biggest concern is. And that'd be the place where, in addition to the foreign ownership, I'd love the department to give guidance. Yeah, this is when you're going to be responsible and how we're going to deal with that.
Right. And the question, there's one question in the guidance on this joint and several liability issue. And I think what's created consternation among entities that non-OPM entities that are potentially third-party servicers is that the question looks at joint and several liability from the lens of the institution, not the third-party service provider. And specifically to Dennis's point, I think we need to use the comment period to urge the department to also address the joint and several liability issue from the lens or the perspective of the third-party servicer. To the extent that the third-party servicer is jointly and severally liable for its own culpability that may have led to a Title IV violation, that's one thing. But if it's somehow jointly and severally liable just by nature of a relationship without any contributing conduct to a potential violation, that's a whole nother thing altogether. And I think Dennis's comment or observation that type of exposure has not been priced into any of the business models is a good one, an interesting one.
Yeah, we just got a great live question, by the way, that I think can help transition us to what's next. But I'm going to read the question because I think it's great. If the DCL continues, does Ed have the capacity to provide the level of oversight to the perhaps hundreds, I'll even say perhaps thousands of TPS providers at each institution? And yeah, I'm very curious because we know that this is going to take a lot of work, not just for institutions and the third-party servicers, but somebody at Ed's actually going to have to look at this or may look at this. And what does that look like? How does this actually going to be enforced? And maybe I'll toss it over to you, Allison, to help lead us through the next section on what's next.
I was just going to say, I think it's time to talk about what's next. And I do want to start off recognizing that we still have a fair number of participants engaged with us for the last 10 minutes. And I suspect that some of them have heard you say, offer comment to the department, weigh in with the department. This may be a new issue and even opportunity to do so. So Dennis or Charlie, can you just give those on the line a little bit of guidance when you say there are opportunities to comment or weigh in? What do you mean by that? And how does one do so?
Yeah, sure. I mean, just real quick, if you go to the Dear Colleague letter, there is a link that says, we're invited to submit comments. You can click on that, and you can go through to the Federal Register publication, and essentially can wind your way to the website where you can post your comments. And it's literally that. You can do it in a letter form and post your PDF, or you can just put it in, essentially like a glorified chat, and they all get treated the same. They all get treated with the same level of respect. Yeah, that would be it. The department has given, I'm just looking here, so it's an additional 30 days that they've given. They were originally was 30 days. So I believe the last day is, you guys correct me if I'm wrong, but I believe it's on or about April 16th or so. But I wouldn't wait. Get the comments in. The department will then review them. This is a new and really different process. The department does not typically solicit comment on a Dear Colleague. Right? That's something you do through a regulation, which suggests to me that they are going to do a notice of change of interpretation related to this, but that's a separate point.
I was going to say that was one of my follow-up questions, though. Does the department have to follow through on this DCL, or do you imagine there will be further clarifications on what's been issued?
I would think there would have to be. I mean, there's going to be way too many questions, and the department would probably serve itself in its regulatory process if it did a formal notice of change of interpretation where it answered these questions in kind of a preamble format. And I say that just so folks, where you've got negotiated rulemaking, which is a very formal process, which I think would be a very good way of doing this. But absent that, it seems the department would have to issue a formal notice of change of interpretation, because the department is literally changing its interpretation. And I know Charlie and I have gotten responses where we've got, the department says to our client, no, you are not a third-party servicer. And right now, they most certainly are a third-party servicer based on this. So I assume they'll formalize that process and respond to the questions in a Federal Register notice. But yeah, you should go on regulations.gov and comment and give them, plenty to respond to. So this way we get quality guidance.
Absolutely.
Yeah.
I'm sorry, go ahead, please.
No, I was just going to say real quickly on the resource question. The department is in terms of budget, one of the largest cabinet agencies, but in terms of headcount, it's one of the smallest. And, the department has always been urging Congress to provide it with greater resources to do its job, which is a pretty multifunctional job. Keep in mind that the Department of Ed through FSA is one of the largest banks in the United States. And through its education statistics function and the administration of student loans, it's one of the largest repositories of data in the federal government. So there's no doubt that the department's resources are going to have to be expanded to encompass not only this, but many other issues. In that regard, I think the department will have to prioritize issues. And it seems to me that in the administration of TPS regulations, the priority really goes to the nexus between the third-party servicer and the administration of Title IV. And the closer the nexus, the greater the priority. And the opposite is true. So one other quick aside is that there were some questions in the chat about instructional content. And I think what the department is getting at there is that, the instructional content or the delivery of instruction is really one of the core functions of the triad, state approvals, accreditors, and the Department of Ed's approval for the administration of Title IV to make sure that the entity that's delivering the education is subject to that. So, the instructional content and delivery focus is a way to try to bring what the department perceives as entities providing education that aren't necessarily encompassed through the triad.
Absolutely.
And
sorry.
I'm sorry, I just want to clarify some. So there are a couple things in the regulatory process. It's 30 days from the date of the letter, right? So the letter was February 28th. So I guess it'd be March 28th. So I just want to correct that. I didn't want to give people bad information there. And then there is also related to the incentive compensation piece, a separate comment period, which ends, I believe, is March 16th. And there are also on the, I believe it's on the 8th and 9th of March, there are listening sessions that people can sign up for if they want to comment on that as well, which again, we didn't talk about much here, but that's an equally critical issue for many institutions.
Maybe we'll do a follow-up webinar on incentive comp. But I don't want to lose the thread on something that came up through Charlie's comments, and that is all that is going on right now, just in the post-secondary side at the department. So in addition to what we've talked about today, we have likely some new borrower defense to repayment regulations. We have some pending accreditation rule changes. We certainly have a Supreme Court decision on borrower debt. And so certainly a lot going on over the coming weeks and months. My final question for each of you, and I'll start, Dennis, with you, Charlie, and then Noah, you can round us out. What should we be watching for? What should we be paying attention to in the coming weeks?
Gainful employment, right? I mean, so gainful employment regulations are at OMB now being reviewed. And that proposed rulemaking is expected to come out sometime, I'm going to say, April, May, somewhere. And then there'll be a whole new comment period about that. There are some other regulations that will be a part of that, including what entities have to sign the PPA. Right? So that's a very critical piece of our institutions. Related to that, just today, there was guidance about when executives have to sign the program participation agreement. And for those who don't know, that's the agreement between the department and the institution that allows them to disperse Title IV. And this would make those folks personally responsible for any liabilities associated with the school, particularly if the school closes. Yep. So I think those are two really big things, I think, to watch out for in the coming months. And then I think let's not forget the department said they're going to notice in its negotiated rulemaking in April, which will start sometime in November. So it's going to be busy year.
I mean, just quickly, I think the big event, the seminal event's going to be the Supreme Court's decision in the debt case. And that, depending on which way, that's going to shape the department for years to come.
Thanks, Charlie. Noah, gonna kick
Yeah.
it back to you.
I was going to say, I totally agree with both Dennis and Charlie, and sort of where, the Supreme Court decision's lasting impact, on what happens with this department. I just say that the negotiated rulemaking side of this, and the fact that we know that, they were at least initially interested in third-party servicers, and where that goes, and how, the comments and the questions that come in may relate to what they do next there. And then the incentive compensation side of this, we know that there's a lot of pressure. I mean, that in a lot of ways may have been what drove this DCL. And so just thinking more broadly, where does that go and what's next? And do they attempt to do that through another dear colleague letter, or rescind the last one, or negotiated rulemaking? I think is going to be really interesting, especially in the context of this. So we're going to end because I think we're right at 2:00, but I'd say if folks have additional questions, please reach out to us. We'll share our contact information following this webinar and the recording. But thank you so much, Charlie and Dennis, for joining Allison and me. Allison, as always, it's such a pleasure to be with you. And just again, please don't hesitate to reach out to us with any other questions. We know there's a lot.
Thank you.
Thank you very much. We appreciate it.
Thanks all.